appeals in the matter of Pfizer Ltd and others and ModernaTX.
Yes.
May it please your lordships, I appear with Miss Hart for Pfizer. My learned friend Dr Tappin appears for BioNTech. My submissions are supported by BioNTech, so Dr Tappin is not expecting to be addressing you separately.
Right.
And my learned friends Drs Appellant and Barron appear for Moderna. As the court will be aware, this case concerns Pfizer BioNTech's COVID vaccine, which played such an important part in the world's recovery from the pandemic. And there were two patents in issue at first instance. Moderna's 565 patent was revoked by the judge and permission to appeal refused. This is the appeal against the findings of novelty and obviousness of Moderna's 949 patent with the permission of the judge, Mr Justice Meade. And we contend that the judge should have revoked the 949 patent for lack of novelty and obviousness. Now, unlike the position before the judge, only claim 3 of the 949 patent is now in issue. This is a result of Moderna's position in the EPO appeal since the trial, where claim 5 has fallen away. Claim 5 had the added integer of the poly-A tail. So for novelty in particular, Pfizer BioNTech's attack is even stronger than it was before the judge, and the novelty attack on claim 3 has more significance within the case as a whole. With your lordship's leave, I was proposing to structure my submissions as follows: deal with the technical background, the disclosure of the patent, the law of novelty, then the disclosure of the prior art, and then show you where the judge fell into error on novelty by reference to the judgment. Then I shall turn to obviousness, deal with the issue of the skilled team, then expectation of success and hindsight, and then explain how the judge would have found the patent lacked inventive step if he had not fallen into error. My learned friend, Dr Appellant, and I have spoken about dividing up the time.
Yes.
And it's agreed that I'm aiming to sit down by 3 p.m, if not before.
And we have to finish at lunch tomorrow.
Yes, my lord.
At some point it would be for the less scientific amongst us to have an introduction, a modest introduction to the underlying science.
Yes, my lord. I was going to do that first of all.
Right. That's your technical background.
Yes, indeed.
Thank you.
So, my lord, the technical background is all in the judgment, but given the circumstances, the judgment is quite long, and so I wanted to highlight a few aspects, if I may. First, by 2010, that's the priority date in this case, it had long been a desire to try to get cells to express proteins of choice. And this was commonly attempted by the use of fluorescent reporter proteins, which spanned wide areas of biomedical research. But there were also specific therapeutic targets, such as generating proteins for vaccination or substituting proteins that were derived from faulty genes in conditions such as cystic fibrosis. Now, one way of making a protein in the cell was by inserting DNA into the cell, but the drawback of that is that the DNA has to enter the nucleus in the cell to be transcribed into mRNA and then into the protein, translated into the protein. And there's also a risk that if you use DNA, that could be incorporated.
Sorry, I'm finding the noise slightly distracting. Can you shut the door, please? Thank you.
And my lord, we're grateful for the indication about wigs and gowns.
Not at all.
So, my lord, there's a problem with using DNA. First of all, it has to enter the nucleus to be transcribed before it can be translated, and also there's a risk that the DNA might be incorporated into the genome, that is the permanent DNA in the cell, and you can't stop it being transcribed in the future. So investigators have thought about using mRNA instead. mRNA is the only type of RNA that can be translated into a protein. And the advantage of using mRNA instead of DNA is that it doesn't need to enter the nucleus to be translated, and there is also therefore no risk of it entering the genome permanently. And it was also easier to synthesize than DNA. But there were problems in particular the stability of mRNA if you inject it into the cell, because foreign RNA is recognized by the immune system and broken down because foreign RNA can be indicative of infection. And related to that, mRNA, if it's injected, is not always translated successfully. So the breakthrough in this work came from the team of Carrico and Weissman at the University of Pennsylvania in the early 2000s. And they first focused on the immune system pathways which attacked the RNA when it was injected into the cell. And they noticed that some mRNAs, which contain naturally occurring modified nucleotides, were not so susceptible to attack by the innate immune system. And these modifications to the RNA take place naturally. And so what happens is some of the so-called canonical bases, that's A, C, G, and U, they are replaced by modified versions of those bases. And in their seminal 2005 paper, which everyone agreed at trial was CGK, Common General Knowledge, Carrico and Weissman identified that the substitution of uridine with pseudouridine in mRNA, amongst other substitutions, reduced the innate immune response that was triggered by the introduction of exogenous RNA into cells. And they also showed that the level of suppression of the immune response was proportional to the number of modifications, so that the best result was obtained for mRNA where 100% of the uridines had been replaced by pseudouridine. And that's an important finding we'll come on to later, which is recorded by the judge in paragraph 251(1) of the judgment. So using these modified nucleotides, the mRNA lasted longer in the cell, and that also gave it more chance to be translated into protein. And the 2005 paper of Carrico and Weissman was one of the papers which was included in the citation for their Nobel Prize in 2023. The UPenn prior art, in this case, which we'll come on to, includes the work reported in the Carrico 2005 paper on the reduced immune response, but it also goes further and includes work showing that not only was the immune response reduced for mRNA, say, containing pseudouridine instead of uridine, but such mRNAs were also translated more efficiently so that more protein was produced. This work on the more efficient translation was also reported in the Carrico 2008 paper, which was the other piece of prior art relied on for obviousness, but which we needn't trouble the court with today. And the Carrico 2008 paper showing increased translation was also part of the Nobel Prize citation for Carrico and Weissman. Of course, the fact that Carrico and Weissman got the Nobel Prize for their work is only knowable with hindsight, as the judge recorded at paragraph 12 of the judgment. But as the judge also recorded in that paragraph, they were eminent at the priority date, and the reader of the prior art would have known that when they read it. So, my lords, that was the technical background. I was now going to turn to the patent in suit, and I think I can probably do this from the judgment rather than having to take you to the core document. And the purpose of this is to show you what the target is for novelty and obviousness. And the judge dealt with the disclosure of the patent in suit at paragraphs 267 onwards in judgment. As I said, the priority date is the 1st of October 2010. But this is in fact a divisional patent in that family, and this divisional was not in fact filed until 2019. I don't get any terms on that, but just for your lordship's note. The background section is dealt with by the judge 268 onwards, and in particular the section summarised by the judge at 270 reflects the problem in the prior art, which I have explained, the problem of immunogenicity and translation of RNA and the problems with using DNA. In 273, the judge quotes from the detailed description, and if your lordships would just look at the second sentence from paragraph 21 of the patent quoted by the judge in 273, what the patent says is, however, it is of great interest for therapeutics, diagnostics, reagents, and for biological assays to deliver a nucleic acid, e.g. an RNA, inside a cell, such as to cause intracellular translation, etc.
Yes.
And the judge highlighted this sentence in paragraph 274 of the judgment as showing that the patent was directed to a skilled team who was not limited to those looking just for therapeutics. It also covered diagnostics, reagents, and biological assays. And as I explained, the most common biological assay at the time was the use of a reporter protein encoding an mRNA, which, for example, would fluoresce when it was translated, so you could tell that it was being expressed. The judge then goes on to deal with the examples in the patent from 279 onwards, and he records that there are 4 examples with data in the patent. And what's important for my purposes is just to highlight that the specification disclosed and tested multiple modifications. There were some 55 different modifications tested in the specification of the patent and listed out in tables 2 and 3. And the original claims of the patent also covered multiple modifications, only one of which was N1-methyl pseudouridine, which is the one that now appears in the claim. And this is relevant to the judge's findings at 286 and 287 of the judgment, where he records that although there was a dispute in the written evidence, by the time of trial, Moderna had abandoned any attempt to suggest that N1-methyl pseudouridine was superior to pseudouridine, or indeed to any of the other modified nucleotides that were listed and tested in the specification of the patent. And so the technical contribution said to have been provided by the patent is therefore just that N1-methyl pseudouridine is better than an unmodified nucleotide, and so it is a mere alternative to using pseudouridine, which of course has been disclosed earlier as part of the common general knowledge in the 2005 work. Your lordships will see at 289, claim 3 is set out. 289 of the judgment, claim 3 is set out, which is the only claim now in issue. And the claim refers to the molecule as N1-methyl pseudouridine. It's called the N1-methyl because the methyl group, CH3 group, is attached to the nitrogen, which is in the 1 position. Elsewhere in the literature, it's also just called 1-methyl pseudouridine instead of N1-methyl, but it's the same molecule. Sometimes it's called M-Cy, the Cy standing for pseudouridine. These are all interchangeable. I'll try and use N1N as a shorthand, if I may. So now I'm going to deal with the law of novelty. The judge set this out alongside the law of added matter because both were alive before him, but the parties, I think, agree that it makes no difference. And indeed, there doesn't seem to be much between us on the law, but our problem is the way that the judge sought to apply it. There's just one point that I would like to develop from our skeleton, and that is the difference between so-called intellectual content and specific teaching in a prior art document, which the judge and the case law both refer to. And I'd just like to make a point from that, if I may. So the derivation of this distinction comes from the Dr. Reddy's case, which the judge set out extensively at paragraph 128 of the judgment onwards. And again, I think I can deal with this from the judgment itself. And as the judge recorded, and you can see in paragraph 23 in that judgment, in that case, the prior art contained a so-called Marcouche formula. That's a formula with groups such as R1, R2, R3, where you can vary the R group with lots of substituents. And it's a shorthand that chemists use to encompass multiple compounds. And in that case, there was a Marcouche which encompassed 10 to the 19 compounds. So there's a typo in paragraph 23. It's 10 to the power of 19. And there was another Marcouche in that case which encompassed 86,000 compounds. And in that case, Lord Justice Jacob approached the matter on two bases. Firstly, as a matter of a priori reasoning, this is his paragraph 25, and then by reference to the EPO case law. And his a priori approach included the example he gives in paragraph 26 of a leaf in Sherwood Forest, and his other example, the reference to the category of books in the Bodleian. That's his paragraph 28. But he goes further then in paragraph 28, and our submission this is clearly obiter, and he says that the phrase books in the Bodleian is no different to providing access to the catalogue of the Bodleian, and that listing out a great number of compounds is therefore no different to a Marcouche. Now, it may not be necessary to resolve this appeal, but we suggest that it's not right to say that there is no difference between the general description of a group and a list of specific items in that group. Because when Lord Justice Jacob gets onto the EPO law, he rightly draws the distinction between the purely intellectual content and the specific teaching of a document. And you can see that in the quote that he gives in his paragraph 30 from the Herxt enantiomers case, and that was a case which discussed what the disclosure of the phrase C1 to C4 alkyl bromide meant in an earlier case called Spiro. And if your lordships can just see the second sentence of the quote from Herxt enantiomers, what he says, what the board said in that case was, with regard to the products of the reaction of the specific Spiro compounds with a C1 to C4 alkyl bromide defined as a group, the board drew a sharp distinction between the purely intellectual content of an item of information and the material disclosed in the sense of a specific teaching with regard to technical action. And they go on to say it's only a technical teaching which can be prejudicial to novelty, and that is if for a chemical compound an individualised description is needed. Now, it's worth going to the Spiro case because that paragraph continues, and the board in that case explain a bit more what they mean by the difference between intellectual content and specific teaching. So if we could go to that, please. It's in the third bundle of authorities at tab 18. And the quote that Lord Justice Jacob has taken this comes from page 800 of the bundle. And it's paragraph 6.1. And if your lordships can see in this report, the sentence about...
Sorry, I thought you said you were going to take us to Spiro.
You're absolutely right. I'm taking you to Herxt enantiomers. I do apologise. Yeah. So it's page 800, paragraph 6.1, and you can see the sentence about sharp distinction. That's the second sentence. Mm-hmm. Then there's only a technical teaching of this kind be prejudicial to novelty. And then the paragraph continues after the reference to individualised description, 6 lines down, and it says, Thus, as the board decided in that case, the purely intellectual content of the terms C1 to C4 alkyl comprises the 8 groups, and they list them out: 1 methyl for C1, another single ethyl for C2, 2 C3 molecules, and 4 C4 molecules. And they go on to say, only the methyl group is disclosed in individualized form, however, since this is synonymous with the lower basic value C1 alkyl. In contrast, the specific alkyl groups with 2 or 3 carbon atoms, included but not enumerated, are not disclosed in this way, nor are the 4 individual groups comprised in the upper basic value C4, which discloses butyl groups only as a generic term. So what the board was explaining here is that the C1 group was disclosed because it was expressly referred to, the text states C1, and it was also individualized because there was only one possible C1 compound that could exist, and so it was both disclosed and individualized. The C2 ethyl was not disclosed because it wasn't referred to in black and white. It was only referred to by virtue of the hyphen between the C1 and the C4. And so because it was not disclosed in black and white, the board explained that it was not individualized, even though there was only one molecule which it could be. Similarly, the C3 molecules were not disclosed or individualized. And then for C4, even though C4 alkyl was disclosed in black and white, none of the 4 individual molecules were individualized because they were not written out separately. They were part of the intellectual content of the reference to C4 alkyl, but they were not part of the specific technical teaching. And so you can see the distinction that the EPO draws between intellectual content, where something is referred to but not set out in black and white, and technical teaching, where it is set out in black and white, and there is only one option given by the reference in black and white. And so in that case, the Herx enantiomers case, the enantiomers were part of the intellectual content by reference to the racemate, but they were not part of the specific teaching of the description of the racemate because they were not individualized, sufficiently set out in black and white. And so what we submit this shows is that the EPO looked to see what is actually written down as a concrete disclosure, as opposed to what is merely conceptually referred to by way of a generic group. And therefore, under the EPO approach, it seems there would be a distinction between the descriptor books in the Bodleian and a list of all the books set out in a catalogue of the Bodleian. Or perhaps taking a more realistic example, it would be a difference in the EPO between a generalised marcouche and an express list of molecules written out in a patent specification. And this is why we say the judge fell into error when he merged these 2 categories in his summary in 130 of the judgment. So if we could go back to the judgment, and go to 130 on page 78 of the bundle, the judge there refers to these, the 2 cases I've already referred to. He refers to Dr. Reddy's, and he refers to the fact that there's 10 to the power of 19 possibilities, and he says that's an easy and obvious case for saying no individualized disclosure. And then he says, but at the other end of the spectrum, the disclosure of a racemate in Herx was held not to be a disclosure of an enantiomer. So far, so good, because both of those cases are cases where there is a generalized disclosure, either the marcouche in Dr. Reddy's or the racemate in Herx. And so he says, well, here are 2 examples at either end of the spectrum. Then he goes on to say, a case in the middle is Almiral and Boehringer, where 159 examples were held each to be sufficiently individualized though the novelty attack failed for other reasons. But the problem that we have with this paragraph is that Dr. Reddy's and Herk's are a different type of case to Almiral, because Almiral, the former two cases were examples of class descriptors, whereas Almiral was a case about an express list, where each of the 159 molecules had separately been written out over 80 pages of the patent, of the prior art in that case. And so we say it's not right to suggest that Almiral is on the same spectrum as Dr. Reddy's and Herk's. It's a different type of case. And in our submission, the EPO does not prescribe the length of a single express list for novelty in the same way that it might be said should take place for a more generic disclosure of a marcouche. And if I can just make that good, if I could hand up a short extract from the EPO guidelines, I'm afraid didn't make it as far as the authorities bundles. And of course I accept these are just the guidelines, they're not binding, but they are guidance that is given to attorneys filing patents in EPO.
Thank you.
And so this is the section from the guidelines, the section, part of the guidelines dealing with novelty. It's chapter 6 of the patentability section on novelty. And there's a section on selection inventions starting on page 7, paragraph 7 of the first paragraph of text after we included the index. And if you're, we could pick it up, second paragraph under 7, assessment of the novelty of selection inventions is dependent on the number of selections identified compared with the prior art, leading to one of the following two scenarios. First thing they deal with is one selection identified, and they say, in the case of one single selection, the following scenarios may arise. A, the selection is a selection of individual elements or of subsets of a larger set, and they go on to say, a selection of one or more elements from a single list of specifically disclosed elements does not confer novelty. And then they go on to deal with selection from ranges and selections from multiple lists, etc. So, as far as the EPO guidelines are concerned, there's nothing there to say that there is a limit to the length of a list that you can pick a single selection from. And it's for that reason that we say both lists of nucleotides in the UPenn prior art that we're going to come on to are individualized because they are written out in black and white. One list is 5 and the other list is 96, but we say in both cases those are individualized in the way that the EPO understands it. And so if we go back to the judgment, and if we go back to first of all, the quote from Dr. Reddy's that the judge provided. And if we can pick it up in paragraph 31 on page 76, this is where Lord Justice Jacob was deliberately avoiding going into what is and is not an individualised description in Dr. Reddy's. But when he goes on to say in that same paragraph, the question of individualisation may be partly one of degree. That's also an obiter comment, and it's not clear that it applies at all to lists, black and white lists, as far as the EPO is concerned. And if I can maybe make these additional observations at this stage, even if there is a limit to the length of a single list under the EPO approach, such that the list is said to be so long that the entry becomes hidden or submerged, to use the language of Lord Justice Floyd in Jushi. Neither side, in this case, has managed to identify a case in the EPO or the UK where a single black and white list in a single place has not been found to individualise its members, such that the entry becomes hidden and not available to the public. And we say that's consistent with the guidelines. So to take another example, it's difficult to see why a list of, say, the 500 patent textbooks on shelf 10 in the Bodleian, that is a list listing out each of those 500 books individually, would not individualise, for example, Terrell within that list under the EPO approach. So if it's there in black and white, it's disclosed and part of the state of the art. Just as, in the same way, for a chemist, the 210 Sigma Aldrich catalogue, which makes many thousands of chemicals available, would also put all of those chemicals in the state of the art. And we also say it's a bit strange, or it seems a bit strange, that Lord Justice Jacobs' other well-known example from the Unilin case of an uncatalogued document sitting in the wrong section of the Alice Springs library being novelty destroying, but a list of 500 books on a particular shelf in the Bodleian may not. And that's a further reason why we say that the EPO is right if it's in black and white in a single list. That is part of the state of the art. And so if we go back to paragraph 31 of Dr. Reddy's, quoted by the judge, the other points that Lord Justice Jacob there makes, which are echoed by the judge, is he goes on, after referring to degree, he says, other considerations may come in too, for instance, the specificity of any indicated purpose for making the compounds. And then he goes on to make his woolly observation, says something, maybe a woolly indication. And in our submission, it's a bit unclear what he had in mind here, because purpose did not seem relevant to the novelty decision in Dr. Reddy's, which was about whether or not the chemical had been disclosed in the prior art or not. And purpose only seemed to come in that case for obviousness. So he may have been extending his discussion into obviousness in this paragraph. And the reason we highlight that is because the judge refers back to this in paragraph 129 on page 78. And he first of all, in 129, emphasises the point about individualised disclosure, and he emphasises the distinction between intellectual content and specific teaching from Herxt, which we accept and endorse. But he then goes on to refer to the question of degree, the pointer of the purpose, and the group list points, that's the list of books in the Bodleian point, all of which are obiter in Dr. Reddy's, and for which reasons I've covered and or will develop in relation to the facts, we say do not apply to the present case. And so, my lords, we say that you have to look at the judge's later findings on novelty with all of these points in mind. So that's what I propose to say about the law, and I was now going to go on and deal with the disclosure of the prior art document before I turn to show where the judge got it wrong in relation to his findings. So could we, for that, please go to the document itself, which is in the supplemental bundle at tab 2. And your lordships will see it published in 2007, title at the bottom, RNA containing modified nucleosides and methods of use thereof. Turn over to the field of the invention in paragraph 1. That refers to molecules of RNA containing modified nucleosides. It refers to delivery of proteins and reduced immunogenicity. Paragraph 2 provides some of the background, and it refers to the fact that nearly 100 modified nucleosides have been identified, and that these are listed in something called the RNA modification database, which was the subject of some of the evidence at trial. And then at the end of paragraph 2, it said, the role of nucleoside modifications on the immunostimulatory potential and on the translation efficiency of RNA, however, is not known. That, of course, that's not quite right when this was published, because when this document was published, Carico 2005 had also been published and was well known. So the role of nucleoside modifications in reducing immunogenicity was known by the time of publication of this document, and of course by the priority date, it was agreed to be common general knowledge. So the reader would see that, but would also have in the back of their mind the common general knowledge that this has already been discovered in the Carico 2005 paper. Paragraph 3 echoes paragraph 1, and then we see the first embodiment of this patent, or this patent application, in paragraph 4, and that is a messenger RNA comprising a pseudouridine residue. There are various further embodiments, including various methods over the next few paragraphs, and then there's a brief description of the figures, paragraph 23 on page 90, and then the detailed description starts again on page 94 with paragraph 38. Again, mirrors paragraph 1 and paragraph 3, and then in 39 you again get the first embodiment, and which also becomes claim 1. The present invention provides a messenger RNA comprising a pseudouridine residue. Further embodiments are set out, and then on the bottom of page 96 of the bundle we get paragraph 56, which is an explanation of what pseudouridine refers to in the document, and they say pseudouridine refers in another embodiment to, and they give a chemical there, and top of the next page, in another embodiment, the term refers to M1 pseudouridine. So that is the molecule that's now claimed in the patent in suit. And there are in this paragraph 5 different pseudouridines listed within the meaning of this UPenn piece of prior art, plus unmodified pseudouridine, so 6 in all. And it's, your lordships will see at line 3 on page 97, there's a reference to M5D, and M5D is not strictly a pseudouridine. It's got a different chemical structure, and there was some evidence about that. But as the judge found in paragraph 335, or reported in 335 of the judgment, there were no other naturally occurring pseudouridines other than those listed in this paragraph, and that could be identified by looking at the database, which is identified in paragraph 2 of the judgment. Sorry, paragraph 2 of UPenn, not the judgment, paragraph 2 of this document. If we go on, please, to page 99, you can see there is a further list of modifications in paragraph 69 at the bottom, and these are the modifications that are tested in the examples in UPenn and claimed specifically in claim 23 of the UPenn application. And then at paragraph 70 on page 100, there is a list of further modifications, and that is all the other modifications that are listed in the database referred to in paragraph 2, excluding those modifications which the authors have already set out in paragraph 56 or in paragraph 69. Then, if you could please turn to page 102, you'll see paragraph 74, and this lists a number of possible percentage replacements for the given nucleotide in various embodiments, and it goes on up from 0.1% all the way to 100% at line 21. If you could go on then to 105 of the bundle, you will see, amongst other places in the specification, in paragraph 82, you're told about the benefits of the invention. So you're told that compositions of the present invention is translated in the cell more efficiently. And then if you look over to paragraph 87 on the next page, the second line, you'll see compositions of the present invention is significantly less immunogenic. So this reflects the introduction and the desire to have better translation and less immunogenicity. Please now turn on to page 121 of the bundle. In paragraph 134 of the specification, you are taught a method of synthesizing an in vitro transcribed RNA molecule comprising a...
Sorry, can you give me the number again?
134 on page 121. And there you're taught a method of synthesizing an in vitro transcribed RNA molecule comprising a pseudouracil nucleoside, comprising contacting an isolated polymerase with a mixture of unmodified nucleotides and the modified nucleotide, and it refers to examples 2 and 7. And then, could your Lordship just read 143, please, on the next page? So this is teaching that you should increase the number, percentage or frequency of modified nucleotides to decrease the immunogenicity or increase translation. In other words, the higher the number, or higher the percentage of replacements you make, the better. And we rely on this as a general teaching. And it cross-refers, it says, as provided herein, and the reader would understand that's a cross-reference to some of the experiments which are coming up, which we will turn to. And those experiments start on page 128 of the bundle, from 170, paragraph 176 onwards. And it's common ground that examples 1 to 15 report experimental results, but examples 16 onwards are prophetic. They haven't actually been carried out. It's also common ground that this work reflects much of what is contained in the Carrico 2005 paper and the Carrico 2008 paper. So there is some serious scientific work reported in this patent, which is not always the case with documents before the patent law. And if we can look at 4 examples in particular. Firstly, example 1, and what Carrico and Weissman were doing here was to test different naturally occurring RNAs for their immune potential. And you can see this on page 131 of the bundle. What they're doing is they're trying different modifications and seeing what the TNF response is, which is an indication of immune response. And they say at line 9 on page 131, the activation potentials of the RNA types tested exhibited an inverse correlation with the extent of nucleoside modification. In other words, the more modifications you have, the lower the immune response. And then they summarize this in paragraph 186. They say, these findings demonstrate that the immunogenicity of RNA is affected by the extent of nucleoside modification, with a greater degree of modification tending to decrease immunogenicity. And we say this is a general teaching, and it chimes with what they promised in paragraph 143, which I showed you earlier. The next example I want to show you is example 2, and this is entitled In Vitro Synthesis of RNA Molecules with Modified Nucleosides. So this is where they start to generate their own molecules with modified nucleosides. And this is the basic method for making the molecules which are the subject of the invention. And you'll see in 187 there are 5 different RNAs listed which appear in the later experiments. You can see, for instance, RNA 1866, RNA 1571, etc. 4 out of the 5 of these are mRNAs, and it is mRNA 1571 which is utilised the most in the examples which follow, but all of the examples where there is data in this document use at least one mRNA in the course of the study. Now, this method is described over the next couple of pages, and it's not in dispute that this in vitro transcription method automatically creates 100% modified RNA for whichever nucleotide you decide to replace. And that is recorded by the judge in the judgment in paragraph 315. And the reason for that is the experimental method, which is set out in paragraph 193. You don't put your canonical nucleotide in, and instead you put in the nucleotide that you want to replace in excess. And that's why you get 100%. And so 193 tells the reader how to carry out that replacement. And then in 194, you can see at line 20, they make and test a number of sequences in length between 0.7 to 1.9 kilobytes. Those are all transcribed, and those correspond to the RNAs that are listed back in paragraph 187, but they don't include the shortest one, the 497. RNA 497 is too short for the range of 0.7 to 1.9, so they must have excluded that from the work they did there. And then they summarise the method in 195. They say, these findings provide a novel in vitro system for production of RNA molecules with modified nucleosides. The following examples 3 to 9 are all about testing immunogenicity, and they reflect the work that had previously been published in the Carrico 2005 paper. Examples 3, 4, 5 and 6 all use only 100% modified RNA. And if you could turn on to page 138, we get to example 7, and you can see that's entitled Suppression of RNA-mediated immune stimulation is proportional to the number of modified nucleosides present in RNA. So this example provides further experimental support for the statements we've seen earlier. And so what they do, as they set out in 212, is they test different proportions of modifications, including 100%. And if you see what they say in the first line of 212, they say most of the nucleoside modified RNA utilised thus far contained one type of modification occurring in approximately 25% of the total nucleotides in the RNA, e.g. all the uridine bases. So the reason they've got the figure of 25% there is because there are 4 bases, so if you replace one of them 100%, you end up with a 25% replacement overall. And the reason that they say most of the nucleoside modified RNA contained one type of modification with 25% replacement or 100% of that modification is there are 1 or 2 cases in the earlier examples where they use a combination, so they use 2 types of modification rather than 1 type of modification, but in each of those examples each of the modifications is 100% modified, just as you're taught in example 2. So every example up to there has got 100% modified nucleotide of each of the nucleotides they've decided to change. And they go on and test these different proportions, and then you can see in 213 they report the results, and they say for the 3 different modifications they've tested, second sentence, each modification, and they list the modifications, inhibited TNF-alpha secretion proportionally to the fraction of modified bases. So again, that's consistent with 143 and the teaching in example 1 we've already seen. And then they confirm that in the last sentence of paragraph 208, just at the top of page 140, and they say, further suppression was observed when the proportion of modified nucleosides was increased. So again, this is a general teaching. It's consistent with what the skilled person would already know from their common general knowledge from Carico 2005. And we say this is about the 3rd or 4th time it's said in the document, and this is a very clear teaching of the document as a whole. We then go on to examples 10 to 15. Those are more concerned with translation, and in examples 13 and 15 they also go on to show effects in vivo. Example 16 onwards, as I said, are prophetic. They also include some therapeutic uses, for example, treating cystic fibrosis. And then if your lordships would please turn to example 31, which is on page 160. And the title of this example is Testing the Effect of Additional Nucleoside Modifications on RNA Immunogenicity and Efficiency of Translation. And what's said is additional nucleoside modifications are introduced into in vitro transcribed RNA using the methods described above in examples 2 and 7, and their effects on immunogenicity, translation efficiency are tested as described in examples 1 to 8 and 9 to 15 respectively. Certain additional modifications are found to decrease immunogenicity and enhance translation. These modifications are additional embodiments of methods and compositions of the present invention. And they then list a series of modifications, and if your lordships look at line 14, the 4th modification along is N1-methyl pseudouridine, the M1-Psi. This is effectively what Moderna went on to do in their patent. They went on to try out some additional nucleotides on their own and in combination, and then they presented the results. So we say effectively all Moderna have done in their own patent is follow the instructions of the prior art, but I'll come to that a bit later, if I may. On page 161, you'll see the claims of this application, and you'll see claim 1 is a messenger RNA comprising a pseudouridine residue, and this is the only independent claim to mRNA. So we say the reader would definitely be interested in this claim if they were looking for improved translation, because they need to have an mRNA, messenger RNA, for translation purposes. So we say that this is a significant claim, not only because it's claim 1, but also because it embodies the new teaching in this document, particularly the new teaching over and above common general knowledge in Carico 2005. So well, that's the disclosure of the document, and now I want to go to the judgment and show you how the judge dealt with that and dealt with the issue of novelty, the 2 routes that we pursued for him.
There were 3.
So there were, yes, 1 and 2 were dealt with together.
Right.
And I can merge the two. I don't need to deal with two separately today. So I'm going to deal with
Well,
route
what does
one.
that mean? I'm sorry, there are either two routes or there's one.
Yes.
I mean, if you're not pursuing one of the three in total, then that obviously simplifies our task, but I'm not understanding the concept of merging two routes.
There is no need for me to pursue route 2 separately. Route 2 was particularly directed at the poly-A tail and going to the specific RNAs set out in example 2. And that it's not necessary for me to pursue that today, although we say it is also novelty destroying for the reasons that I'll explain.
But we can focus attention on routes 1 and 3.
Indeed.
Thank you.
And I was proposing, because it's dealt with chronologically in the way I take you through the document, I was proposing to deal with route 3, which is the claim 1 and para 56 route first, because that's the way we dealt with it in our skeleton, if that's convenient. And so the starting point for, we can turn it up at the in the judgment. Judge deals with this at paragraph 330 onwards. And so first of all, I give you my submissions, having looked at the document, and then I'll show you where the judge went wrong. So the starting point for route 3 is paragraph 4 and claim 1, as the judge correctly identified. And as I pointed out, we would submit that the skilled reader would see that paragraph 4 and claim 1 are clearly preferred. It is the main claim, it's the first embodiment in the document, and more importantly, it's the only independent claim to mRNA, which is a key part of the teaching given the translation benefits that are taught. So you read claim, the reader looks at claim 1, and they need to use the specification to understand what is meant by the reference to a pseudouridine residue in claim 1. And for that, they have paragraph 56, and everyone agrees that paragraph 56 is at very least a definition paragraph, and therefore, having read what is you're told by the authors of the document in paragraph 56, the reader would understand that the pseudouridine in claim 1 would encompass N1-methyl pseudouridine, which is referred to in paragraph 56. And that seems to be accepted by my learned friends in paragraphs 33 and 34 of their skeleton, and is also accepted by the judge in paragraph 335 of the judgment. So the issue is there are 5 pseudouridines in inverted commas in paragraph 56, and does that prevent N1-methyl pseudouridine being disclosed or individualized as part of that? And we say not. We say N1-methyl pseudouridine is plainly individualized in the list of 5 pseudouridines in paragraph 56. And we submit that the inclusion of the language at the end of paragraph 56, or any other pseudouridine known in the art, cannot detract from the individualized disclosure of those molecules which are set out in black and white in that paragraph. And of course, we also rely on the fact that the evidence was that there were no more naturally occurring pseudouridines. But that's not necessary for our argument. We say that the reader can see that N1-methyl pseudouridine is individualized, and it's really irrelevant whether there are or there are not any other pseudouridines known in the art. So we say, if N1-methyl pseudouridine is plainly set out in black and white in paragraph 56 and would be understood to be encompassed by claim 1, all that could possibly be missing from the claim in Moderna's patent is a 100% replacement of uridine from paragraph 56. But we say that is also plainly taught as a general preference throughout the specification. And I've taken your lordships to those paragraphs. It's the method of example 2. It's also the standard in vitro transcription method, which was used at the time. It's the default. And all of the immunogenicity examples which follow use that same method of example 2, and they all use 100% replaced nucleotides, as I've explained. It's right that example 7 examines varying the percentages and does try other percentages, but it concludes at paragraph 218 that having tried these other percentages, the greater percentage of replacement gives the lower immunogenicity. So the conclusion from example 7 is consistent with the general teaching elsewhere, which is that 100% replacement is best and is preferred. And we've also seen the explicit references to teaching the highest percentage in paragraph 143 of the specification, in paragraph 186 of the specification in example 1, and at the end of example 7 in paragraph 218. And these are all general teachings applicable to all nucleotides. And so we rely on the fact that in the EPO, having multiple statements and multiple examples all doing the same thing is an established way of teaching a preference and individualizing, particularly when that teaching is expressly said to be general. You're not simply just picking out a number of examples which happen to have 100%, because the document tells you that they have 100% for a reason, and there is an advantage to doing so. And so that's why we say it's an even stronger preference. It's also consistent with the common general knowledge, and when we say that, we say in the right sense of interpreting the document in the light of the common general knowledge. We're not seeking to add to the disclosure of the document, and the judge noted these distinctions in his paragraph 337, and he also noted there that the common general knowledge was that it was easier to do and more reliable to make 100%, and we say that the skilled reader is entitled to read the document with that common general knowledge in mind, and that simply goes to reinforce what they are told elsewhere in the document, that 100% is preferred. So we say it's taught in multiple places as being the best. It's clearly, it's general teaching, and it is clearly preferred. And so the skilled reader is entitled to take claim 1, the express disclosure of N1 methyl pseudouridine in paragraph 56, and the general teaching, and for all those reasons we say that claim 3 is clearly and unambiguously disclosed in the prior art.
Can you just dissect the end of paragraph 337 for me?
Yes, I was going to go through each of the judges' paragraphs. Is it more convenient if I do it?
Okay, if you're coming back to it,
Yes,
that's
I will
fine.
definitely
You
come
mentioned it, I was looking at it, and it was the end of it. I was just come back to it.
If I haven't dealt with the point when I've, I will of course do so more. So the judge dealt with it at 330 onwards, and the heart of his judgment is at 335 to 339. And of course, the judge was having to look at claim 5 as well as claim 3, which explains his reference to poly-A tails in, for example, paragraph 333, but that's not something that need concern your lordships now. So if I start with 335, the judge there says that paragraph 56 is, in his words, an odd creature, because he says it's a definition and not an expression of technical preference. With the greatest respect, we don't understand what's wrong with it being a definition, because it provides the list of pseudouridines for Claim 1. And in this sense, it could be said to be a technical teaching because it defines the list of pseudouridines in Claim 1. But in any event, everyone's agreed it is a definition and it applies to Claim 1. He goes on to say it's not clear why these 5 have been picked, but it's not in dispute that the rest of the document shows the superiority of pseudouridine, that is the pseudouridine molecule, over the other modifications tested. It's also not in dispute that Carricker and Weissman were well known and respected by the priority date, as the judge pointed out in paragraph 370. And so the skilled reader would assume that Carricker and Weissman had a reason for writing out the 5 molecules that they did in paragraph 56. Now, as I've hinted, the first error that the judge made was to rely on the fact that paragraph 56 was apparently open-ended because it referred to other pseudouridines known in the art. That is to say, given that there were no other natural pseudouridines, that must have been referring either to artificial pseudouridines or pseudouridines that might be found naturally in the future. But as I've explained, we don't understand how that can make any difference to what is actually individually disclosed in paragraph 56. And in our submission, N1-methyl pseudouridine is clearly individualised. It's written in black and white, and the EPO would consider that it was properly disclosed.
I mean, the sentence, it is also open-ended because of the reference to any other pseudoephedrine known in the art. I mean, it's not inaccurate as a sentence.
It's not inaccurate, but we say it's irrelevant to what is disclosed. It can't prevent N1-methyl pseudouridine being disclosed by the fact that there is a possibility that
Does the judge say it is?
Well, he seems to. A number of occasions he also refers to it in relation to paragraph 31. Yes, he comes back to it at 339,
Okay.
where he says it's the last line of 339, something in an unclear and apparently open-ended list. So he does seem to rely on the open-endedness later, and we say he was wrong to do so.
Okay.
And of course, we're not trying to rely on paragraph 56 for the disclosure of some different pseudouridine not mentioned or found in the future. And we say that the judge has distracted himself from what is disclosed by placing weight on this point. Then we turn to paragraph 336 of the judgment, and the judge says there that N1-methyl pseudouridine is not preferred. And again, I'm afraid, just don't understand the relevance of that, because in our submission, each of the 5 molecules are individualised as pseudouridines, and there is no need for a preference of N1-methyl pseudouridine over the others that have been specifically identified as well. The question is only whether there is a clear and unambiguous disclosure of N1-methyl pseudouridine, and we say there is clearly, or there's plainly a clear and unambiguous disclosure of 6 different modified mRNAs, that is to say, containing each of pseudouridine itself and the 5 additional pseudouridines of paragraph 56. So we say no need for express preference, they're all disclosed, and the judge was distracted again by his looking for a particular preference. Then in 337, he turns to the 100% point. And if I just jump on first of all to 338, he does accept in 338 that there are pointers to 100%, which in our submission should really be the end of the matter. But instead the judge rejects those pointers on the basis that they are not strong, not explicitly disclosed, and not directly linked to the list in paragraph 74. And the thinking behind these conclusions seem to be set out in paragraph 337. And we say there are a number of mistakes in paragraph 337. Firstly, in the first sentence, the judge says that while example 2 gives a method for achieving 100% replacement, he says it does not necessarily make it preferred. But we say the fact that numerous examples start with example 2, and each of those have 100% replacement, shows that the use of example 2 throughout the set of examples which follow is a clear preference or pointer. As are the express statements throughout the specification about wanting the highest percentage to reduce immunogenicity. So when the judge says in the brackets in line 3, a lesser percentage might be just as good, he is ignoring the clear teaching of the document.
Can you remind me where the highest comment is made?
It's the three places I've shown you where they say that increasing the proportion.
Can you just remind me?
Oh, sorry. It's 143, paragraph 143, paragraph 186, and paragraph 218 of the prior art.
So 186
Yes.
says these findings demonstrate that the immunogenicity of RNA is affected by the extent of the modification with a greater degree tending to decrease in immunogenicity.
Yes.
And an inverse correlation. It doesn't actually say, I thought, quite what you described it as saying.
Well, it says that the more you replace, the less immunogenic
That I understand.
and therefore the maximum immunogenicity must come from 100%. That follows. I of course accept that doesn't expressly refer to 100%, but we say that the teaching is a general teaching in relation to a number of different nucleotides, but it also the teaching is general to the extent it says the more you replace, the lower your immunogenicity.
Tends to decrease. I mean, okay, so you say that's making specific that 100% is the best.
Yes, I mean, I of course I accept it tend to, that is, it's not definite, that wording, but if you combine it with what's in 143 and when they go on expressly to test which percentage is best in example 7, and that's when they 213 and 218, and in fact they've got some graphs later on where they show different percentages, and you can see that 100% is the best. I think it's figure 6.
Well, should we have a look at that? Because it will take us to that. Sure.
Yes. So if you go on to page 174 of the supplemental bundle, and you see figure 5C, and there they've got the 3 different modifications that they try: M6A, pseudouridine, and M5C, and they've got 0% replacement, 1%.
This is example 7, is it?
This is example 7, yes.
Yeah.
0%, 1%, just reading down for M6A, for example, 0 is 1, 10, 50, 90, 99, and 100. And I perfectly accept that it's quite difficult to see if there's any difference between 99 and 100 in those figures. But the teaching is, we say, absolutely clear that 100% gives you the best inhibition of TNF-alpha, expression TNF-alpha being an indicator of immune response.
So you're saying the judge is wrong to say a lesser percentage might be just as good?
Correct. Just goes against all of the teaching of the document, and indeed the common general knowledge from Carrico 2005. And so he then goes on, he's right to say in the next part of that sentence, he says, I do accept that achieving 100% would be seen as easier to do and more reliably than the other possibility. And the reason he says that is it's easy to do because you have the nucleotide in excess, so you know they've all been replaced. And it's more reliable because if you have 100% replacement, you know that every single nucleotide has been replaced. If you have 50% replacement, you might have one molecule with 50% with the uridines replaced in one position, and then another molecule with 50% of the uridines replaced in different positions, and so you get more of a melange of molecules, and so it's more difficult to interpret the results you have. So with 100%, you can easily control precisely which nucleotide is substituted and which is not possible with lower percentages. So the judge is right to say it's easier to do and more reliable there. That was consistent with the common general knowledge and is yet another pointer to doing it at 100%. But again, we take issue with his words, but the same applies, to the extent he seems to be saying a lesser percentage might be just as good. That is contrary to the teaching of the document in numerous places, including example 7 and the figures that I've shown you. Then he goes on in the next sentence to say, he refers to example 7, and he says that example 7 shows that 100% is not necessary. And the problem we have with that is that necessary is just not the right test.
My question was necessary for what?
Well, I think he's saying there, you could make something with 50% replacement. And example 7 shows you how to do that. And it's right that example 7 does show the skilled person how to make something which has not got 100% replacement. But that doesn't take away from the general teaching of the document that having made and tested 10%, 20%, 50%, the teaching is that 100% is best. And so once you've seen that example and seen the data and understood the teaching, the skilled person knows to go on and make 100% next time, because that is going to give the optimum response. And the reason we...
I'm not sure I'm following the difference between preferred and necessary.
Well,
which is why I asked you to look at this.
Our problem with necessary is that it doesn't have to be nothing has to be necessary. It only has to be preferred. If you were looking for a test that required the document to say something was necessary, then you'd never be able to use a preference, because a preference is only a preference. It doesn't. A preference is never necessary. It's merely something that might be preferred. You might choose to do for a reason, and the document has pointed out. So we say that if the test that should be applied is a necessary test, you could never rely on pointers or preferences, because a pointer or a preference is by definition not something that's necessary. So we say that he was using the wrong test when he referred to necessary in that penultimate line. And so we say that 100% is clearly preferred, as taught by example 7 and in the other places in the specification. And we say that the pointers to 100% are both strong, contrary to what he says in 338, and explicit, contrary to what he says in 338, for the reasons we've gone through. And in any event, we say that the EPO says that implicit pointers are allowable anyway, so that shouldn't be a reason, even if the judge was right. And as Mr. Tappin points out, the judge seems to have got it right in paragraph 139 of the judgment, where he's talking about pointers, and he's talking about what may be a pointer, and a statement of preference within a list is a common pointer. And he's absolutely right to make that observation in paragraph 139 of the judgment. So that's why it's a little baffling that, having made that correct observation in 139, he reverts to trying to look for whether or not 100% was necessary in 337, as opposed to just seeing, is there a pointer to 100%, or is there a preference to 100%? And we say that given the wealth of material pointing to 100% replacement in the document as preferred, there is both a pointer and a preference. And because of the wealth of that material in the document, there doesn't need to be a direct link to the 100% referred to in paragraph 74, as the judge seems to think in paragraph 338, because the general teaching is enough. Finally, in 339, the judge criticises the absence of a pointer to the combination of N1M and 100%. And say, we don't understand that. It doesn't make any sense, given that the 100% replacement is a general teaching applicable to all constructs. And then he returns at the end of 339 to say 56 is an unclear and open-ended list. In our submission, it's not unclear, because it sets out the 5 molecules. And even if it was really open-ended, that doesn't matter, because N1M is expressly called out there. So for all these reasons, we say the judge clearly fell into error, and there are clear and unmistakable directions to make something falling within Claim 3 of the patent in suit in UPenn, paragraph 56, and Claim 1, that route. And that is to say an mRNA with N1-methyl pseudouridine, which would be 100% replaced by following the teaching and preference of the document. Now, my final point on route 3 is Moderna now try to run a point, not run before the judge, not foreshadowed anywhere in the evidence of trial, and not in their respondent's notice about example 11 of UPenn. It's in our submission desperate stuff, but it's perhaps best addressed once we see whether my learned friend really is advancing that point, or seeking to advance it, and how. So I may have to come back to that in reply. So, my lords, the alternative, and we say equally valid, route for destroying the novelty of Claim 3 is via example 31. And that's the routes 1 and 2 dealt with by the judge in the judgment. And of course, as you'll have seen, the difference with route 3 is that although there is a longer list of nucleotides in example 31 than listed in paragraph 56, in our submission, 100% replacement comes from the express teaching of the example, and so there's no need to even rely on the general teaching in the document for that. And so turning first to the list of nucleotides in example 31, and perhaps it's helpful to just go back to that in the document. So it's supplementary tab 2 at page 160. Our first submission is that even though we of course accept that this is a longer list of 96 nucleotides, each and every one of those nucleotides is individualized, and N1-methyl pseudouridine is expressly shown on line 14. And so we say, for the reasons I ventilated earlier, because this is a single list,
Well,
that
this raises the question of what one means by an individualised description. I mean, you're clearly right in the sense that it's individually listed. But why does that make it an individualised disclosure?
because we say it's not mere intellectual content. There is a technical disclosure by virtue of the fact that the molecule is expressly referred to, and that seems to be the way that the EPO approaches this, as I showed you in the Herx case.
But what's the logic?
The logic is that
Because I mean, as I think you acknowledged earlier in your submissions, in principle you can write out a Marcus in seriatim. So rather than have one formula, you can have a list, and the list may be half a page, it may be a whole page, it may be 10 pages. Why does it make any difference?
Well, we would say that it's not in dispute that the contents of the Encyclopaedia Britannica are part of the state of the art. That's a very long document, but the words are there in black and white, and that would be seen by the EPO as destroying novelty, something you tried to claim that was contained somewhere within the 10,000 pages, or whatever it might be, of the Encyclopaedia Britannica when it used to still be printed. And so we say it's no different for a single list written out in black and white. We say there is technical disclosure in the sense of the EPO of N1-methylpseudouridine in that list. And we say that even if there is a cut-off somewhere, and having a list that's too long does lead to something being submerged, this is the right side of the line. That the only data point you have is the Almirall case, where there were 159 individual molecules set out over 80 pages of the prior art. And no one suggested at trial that that was wrong. My learned friends, I don't understand, suggest that that is wrong today. So, of course, I accept that you can't simply put a number on it, and there is no strict cut-off, if there is a cut-off at all. But given that 159 was not too many in Almirall, we say that 96 is listed in 7 lines of text, is not too many in this case, and each and every nucleotide in this list is sufficiently individualised, disclosed and individualised for the purposes of novelty. They are all part of the state of the art. And after all, what are we trying to do here? We're trying to stop somebody repatenting something which is not new.
Sorry, can I go back? Sorry, I'm just trying to catch up, really. You introduced this by saying this is, in example 31, you've got an express mention of M1, and you said you don't even need to go for the general teaching relation to 100%.
Yes.
Can I just understand what this example 31 is supposed to be?
Yes, of course.
Example 31, as I understood your introduction, was forward-looking, i.e. it's something which has yet to be done but is suggested, prospective.
Yes.
And what it says is at 290, additional nucleoside modifications were introduced into in vitro transcribed RNA using the methods described in 2 and 7 and tested is described. Certain additional modifications are found to decrease immunogenicity and enhance translation. Certain additional ones. These modifications are additional embodiments of methods and compositions in the present invention. Now, there's then just modifications tested include, and then there's just a big list.
Yes.
But how do you know which of that big list are the certain additional modifications that are found to decrease immunogenicity and enhance translation? If I'm just looking at this, I mean, how do I know?
Yes. The answer is you don't need to know, because the claim, the target we're trying to hit is just You just have to make the mRNA containing the modification. That's all you have to do to be within the claim. And what this example is, it's an invitation to the skilled reader to make mRNAs with these additional modifications in order to test, to find ones that decrease immunogenicity and enhance translation. And by carrying out the experiment, regardless of the results, if you make M1 methylpseudouridine containing mRNA, you are within the claim. So it doesn't matter that this is prospective, nor does it matter that the example doesn't tell you which of these are promised. As the judge found, there was a promise here of improvement. It doesn't matter that the example doesn't tell you which ones meet that promise, because you don't need to achieve that to fall within the claim. Of course, inevitably you would. If you make N1 methylpseudouridine, it is better than unmodified. That's not in dispute. So in that sense, it doesn't matter either, because even if
we wouldn't be here otherwise.
No.
Usual story.
Usual story. But the point is, because the claim in the patent is limited to merely the mRNA, including the nucleotide, then this invitation to make the mRNA, including the nucleotide, is sufficient to destroy novelty. And of course, the patentee could have sought to claim something different. They could have sought to add to their claim. They could have sought to run the argument at trial that actually N1 methylpseudouridine was better than anything else. They didn't. They abandoned that. So all you are concerned with as a target is the mRNA itself. And we say this is a clear and unmistakable direction to make that mRNA with N1 methylpseudouridine. And the other points arising from example 31, of course, are that it teaches that all of the modified nucleotides should be tested for translation and immunogenicity. And if you are going to test the N1 methyl modification for translation, you have to make an mRNA to do that, because the only thing that could be translated is an mRNA. And it also teaches you to use the method of example 2 to do that. And if you use the method of example 2, you must make an mRNA with 100% replacement. So all of the elements of the claim in the patent are taught by example 31. mRNA, 100% replacement, and using N1 methylpseudouridine. Now, in the judgment, the judge deals with this at 322 onwards. He sets out Moderna's arguments, and then he says in 322 he prefers Moderna's position. And the points that he summarises as coming from Moderna, those are set out in 321, 1 to 10, sorry, 1 to 9. But your lordships will note that the points towards the end of the list fall away because they're more concerned with the poly-A tail, which your lordships don't have to worry about anymore. So if I go through the points which are still relevant and which the judge relies on, the first point is in 323, where he holds that the instructions in example 31 are what he describes as extremely tentative and open-ended, and the reasons for doing it are woolly, he says. And again, with the greatest respect, we just don't understand those observations. In our submission, the instructions in example 31 are clear. The reader is told to test the additional modifications for translation efficiency and immunogenicity to find alternatives to those that have already been tested. And the reader is told to carry out those tests using in vitro transcribed mRNA, because you have to use mRNA for translation, and the methods of example 2. And so the reader is told exactly what to do and exactly why they are doing it to find alternatives. And so in our submission, example 31 is not woolly at all. And then the judge also gets distracted by the alleged open-endedness of example 31, where we say he should instead have been focusing on what it does tell you and not what other things might be included, about which there was really no evidence. Then in 324, the judge says that example 31 is not teaching you to go back and do example 2. He just says it provides methods that may be used. This is the first sentence of 324. Again, with a great respect, that's not what the example says. If you still have it open, the example tells you to use the methods described above in examples 2 and 7. There's no may about it. The reader is told to do it. And the reader is therefore told to make in vitro transcribed mRNA per example 2. And as we've seen, what example 2 teaches, and what indeed the document as a whole teaches, and consistent with the common general knowledge, is 100% replacement, which is in any event the default position using this method.
So that submission highlights something I was thinking about anyway, which is that when you are articulating your case on example 31, you use more than once the expression clear and unmistakable directions to make. And I understand, of course, that way of putting it, but it's not apparent from the judgment that was how it was put to the judge. It seems to have been put more on the basis of clearly and unambiguously derivable from. Now, one can debate forever and a day the difference between those two approaches, but nevertheless they seem to be recognised in the case law. And speaking for myself, I can understand why you might choose, particularly with this route, to focus more on the latter than the former. But is that how it was put to the judge?
Well, I apologise. In my own mind, I don't see a distinction. There is a single novelty test, and obviously we can use different words to describe it. But
one sees both formulations
I accept
in
that.
the case law.
I accept that. In the end, you've got to ask: is it new or not?
To be sure, but that's why I'm asking the question.
Yes, we can check this over the short adjournment. I don't think that we sought to make a distinction between the two before the judge, and the fact that I use the two interchangeably is obviously my fault, and I may be wrong to do so. But we're not aware that we're putting the case any differently now than it was put before the judge. And we can also go back and look at the novelty table, and there were quite extensive submissions on the law before the judge. And we don't criticise the judge for using one test rather than the other. We just say that he got the disclosure wrong, and that's why he fell into error. But if I may, I'll come back to you on that, my lord, if necessary. So we were dealing with the instruction to use.
It can make a difference. You may be right to say that on the facts of this case it doesn't matter, but we all know it can make a difference in some factual circumstances. I mean, the normal example where it can make a difference is if you have a recipe and the description of the recipe doesn't tell you expressly what the end result is, but if you follow the steps, you find out that what you get is in fact within the claim.
Yes. Yes.
And if you look at that in terms of clearly and unmistakably derivable, you might say, well, no, it's not, because it doesn't tell you expressly what the result is. But if you apply clear and unmistakable directions to make something falling within the claim, yes, it satisfies that test.
Yes, your Lordship's absolutely right. And I think that's the distinction that Lord Hoffman draws into Synthon.
Yes.
Where he deals with the clear disclosure and then he deals with the clear and unmistakable direction. And your Lordship's absolutely right. And if we say that both routes get us home here, in that there's clear and unmistakable disclosure to do example 2, which gives you 100%, because that's what the skilled reader understands example 2 to do. And there are also clear and unmistakable directions that would result in something which had 100% and was an mRNA. And perhaps we say it's clear from this that you are being taught to test for translation, and that must involve making an mRNA. But to the extent that it could be suggested that it doesn't say it in black and white, that it's an mRNA, then of course, if you are testing for translation, you must be making an mRNA, and so we would say that it is...
well, yes, and so to that extent, one could say, well, example 2 is a recipe.
Yes, yes. And Ms Hart has reminded me that in our table, that's right at the back of the supplementary bundle for the example 31 route. So it's supplementary bundle tab 25, tab 27. We say in the comments right at the end, in column 1, as such, UPenn contains clear instructions to make something that will infringe those claims / clear and unmistakable directions to do.
Sorry, where are you?
Sorry, I'm in page 337 of the bundle.
337.
Very last page of the bundle. And in the very last comment...
Sorry, page supplementary bundle 337.
Yes, I hope your Lordships have that. Maybe it hasn't made its way into...
Well, I have it.
Oh yeah, I got it. It's not actually. Sorry, it's
It's horizontal, so it may be difficult to read.
No, it's just that the electronic number is not the same as the.
Apologise. It's 350, I'm told.
Yeah, thank you. Sorry.
I'm used to them being 1 out, but
Yes.
13 out is a lot.
Every single tab must have added a page, I suspect.
Sorry, that's just made it life. Yeah, okay, anyway, I'm there. Sorry,
I do
where were you?
apologise.
Sorry, where were you then?
So the very last paragraph, we refer to clear instructions to make something that would infringe, / clear and unmistakable directions to do what the patentee claims.
Sorry, I'm reading what you said, but I'm trying to get some context for this. So I understand that this is your novelty chart.
Yes.
But how does this relate to which route is which?
Yes. So this is if you go back to 335, 2 pages earlier, you can see example 31. There are 3 columns.
Yes.
And it's routes 1, 2, and 3 across. So this is route 1, and we set out.
Well, so on that basis, it's route 2, isn't it?
Well, it's route 1 and route 2.
Oh, it's the same.
Yes.
It's the same language in both.
Yes.
Okay. Now I've understood. Okay. Thank you.
So we've set out the disclosure above. This was pursuant. The judge asked us to do this in closing to help him, and we explain above that example 2 tells you to make 100% replacement, etc. That you're told to do translation, etc.
But the point is that your answer to my question is you did make the submission to the judge because it's in the chart.
indeed.
Thank you.
And so we say that is the teaching example 31. And even if the judge was right and it was optional to follow example 2, we say there's clearly a strong preference to do so, and so that's a sufficient pointer for all the reasons we've been through. Because claim 5 has fallen away now, it's irrelevant whether the reader interprets the instructions as only to use the methods of example 2 and not actually to reproduce the very same mRNAs, or whether the reader just interprets as making any mRNA or making the mRNAs in example 2. Either way, you need to make an mRNA to test for translation, and therefore you would make an mRNA with 100% replacement. And we note that there's, of course, no specification or reference in the claim in the patent in suit to what the mRNA needs to be. It just can be any mRNA, so we meet that test at the level at which the claim is set. So just continuing the judgment, in 325, the judge acknowledges that N1M is present in black and white, but he says it's not necessarily individualised. I've explained why we say that's wrong as a matter of law, and in particular we take issue with the second sentence. The fact that options are in a list rather than described as a group means that it is not merely intellectual content, but it is a specific teaching, and that's the Hertz case I showed you earlier, an explanation there. The last sentence of 325, it's a quadruple negative, but I think it appears to be a tentative finding that the list of 96 is not individualised. And as we've explained, we don't understand why that is the case, even if the judge was right to apply paragraph 28 of Dr. Reddy's, because the list there is smaller than the list of 159 in Almirall, which no one disputed was individualised. And in fact, we say it is all expressly disclosed that the EPO requires. The judge gives no reasons why the list is not individualised, or why N1-methyl is not individualised in the list. He again seems to place weight on the fact that the list is open-ended, and that's his reference to include, e.g. in the last sentence. But as I've explained, even if that mattered, it doesn't take away from the fact that the 96 that are there. And the judge's tentative finding in relation to individualisation is apparent in 326, because he goes on to say, well, I'll go on to consider it even if I'm wrong about that. And this first sentence of 326 contains just a double negative, where he seems to be saying that there's a selection from lists, that is to say N1-methylpseudouridine and mRNA. But we say the judge was wrong about that, because the reader is instructed to test for translation, and so must make an mRNA. There is no need to select from any list to do that. And we say it's irrelevant that the skilled reader is also asked to test for immunogenicity, because all you need are clear and unmistakable directions to test for translation, which would require mRNA. And so the judge is wrong insofar as he relies on Moderna's submissions at 321, 5 and 7 to take account of this. And in fact, this seems to be really consistent with a later passage in the judgment, because if you go to 377 of the judgment, the last sentence, the judge agrees with us that the skilled person would think that translation was of importance, because the advance of New Pen over Carico 2005 was in that area. And so we say if anything, there is a strong preference for testing the translation in example 31, because that's the new and better bit of UPenn over and above what the skilled person would already know from their common general knowledge in Carico 2005. Even if the skilled person did understand example 31 as teaching you to do precisely what is in example 2, i.e. use the same molecules, then, as I showed you earlier, 3 out of the 4 molecules that results were given for in example 2 are mRNAs. So even on the judge's approach, there is again a strong preference to make mRNAs. But as I say, the better argument and the better point is that you have to make an mRNA if you are following the instructions to test for translation. The remainder of paragraphs 326 and 327 are where the judge is, and this is not a criticism of him, but he was distracted by having to focus on RNA 186 because he was having to look for the poly A tail that was required by claim 5. And so to the extent he is analysing the arguments on the basis of multiple lists, that's because that's the only way the anticipation argument could work for claim 5 in example 31. So you can disregard those passages because it's no longer the case that you have to find the poly A tail, so therefore the second half of 326 and 327 no longer apply. The key question is not just would you make RNA 1866, which is the one which had the poly A tail, and the selection is no longer just 1 out of 5, as I've explained. And as I say, in fact, the judge was wrong to say it needs to be any of the mRNA constructs used in example 2, because any mRNA would do. Just all you need to do is test for translation. There's a further discussion in 328 and 329. Again, that is on the wrong foot as far as your lordships are concerned, because the judge was again worried about the poly A requirement. But even then, it's clear in our submission that the judge has fallen into error in his earlier analysis, because he again suggests that mRNAs were only useful for some of the purposes of example 31, when we say they were in fact essential for example 31 for testing translation. And so if you follow the instructions of example 31, you have to make mRNA, and pointers don't come into it at all, because there is an express direction to make a compound of claim 3 of the patent in suit. And so, in summary, there's a clear instruction to test for translation, so it has to be an mRNA. It has to be 100% replacement, because that is required by example 2, is preferred in all the places we've looked at in the specification, and it is was known to be the default in the common general knowledge. And so, for all those reasons, my lords, we say that claim 3 of the patent suit is also anticipated by example 31 of UPenn, and the judge should have found that in addition to finding that claims 1 and paragraph 56 anticipate. So the final thing the judge does in terms of novelty is go on to discuss the decisions of the EPO and the Hague, the former which agreed with him and the latter which revoked the patent for lack of novelty, as we submit your lordship should do. I don't propose to go into...
Well, they're both under appeal.
They're both under appeal. They're not in the bundles. My learned friends don't seek to rely on the EPO decision and the reasons which weren't available to the judge. They haven't relied on that as part of their respondent's notice. So I was going to leave it at that and say that we are right for the reasons we give. And although, of course, we say the Hague...
But you will nevertheless understand the reason for me inquiring when the Board of Appeal will be hearing this case.
Yes. So your lordships have it. I think the appeal in the Hague is in September of this year, and then the Board of Appeal have set 3 days for this hearing in September 2026. They did that last week. So
Why 3 days? That's unusual.
there hasn't been a preliminary opinion. All they've done at the moment is just set the date for the hearing.
Okay, thank you.
So, my Lord, unless there was anything else your Lordship wished to raise with me on novelty, that's my appeal on novelty, and I was going to now turn to the topic of the inventive step. And my Lord, the overview on inventive step is this. It's a very striking thing about this case is that the basis of the judge's decision on novelty over paragraph 56 in particular was the absence of a combination of N1-methylpseudouridine and 100% replacement. Yet the one thing that's not in dispute, as far as obviousness is concerned, is that 100% replacement would be the obvious thing to do when you were replacing nucleotides. And that is a finding of the judge in paragraph 362 of the judgment. It just wasn't in dispute below. So we are in what we would submit as a very strange position, where the only point which prevented the judge finding claim 3 not novel over claim 1, paragraph 56, completely falls away when it comes to obviousness. Yet the judge still found that it was not obvious to carry out claim 1, paragraph 56 of UPenn with 100% replacement. And we recognise that this court will normally be reluctant to interfere in an obviousness determination. But we say in this case it's very clear that the judge has gone badly wrong. And we ask, how can it possibly involve the exercise of invention to make an mRNA according to claim 1 of the prior art with 100% replacement using one of the 5 pseudouridines identified in the prior art? And we note that, as I've explained, all Moderna really did in their patent was to follow the instructions or the in UPenn test multiple nucleotides and now claim a 20-year monopoly over one of the nucleotides that's expressly called out in the text of the UPenn document. We say that result is wrong. Now, in the judgment, the crunch part of the judge's decision on obviousness comes at paragraphs 415 and 416. So perhaps I can start there and show you why we say the judge is wrong. And in those paragraphs, the judge sets out the 3 factors which he says influenced him on his decision on inventive step. First is what he calls the hindsight approach to paragraph 56. And he goes on to say there's no pointer to try the other pseudouridine modifications. And to a great extent, I've already been over that. We say there can be no hindsight in the reader of UPenn focusing on paragraph 56, because it provides the very definition the reader requires for claim 1, which is the only claim, independent claim, to mRNA, which is a core part of the teaching of the document. So we say no hindsight in reading claim 1 and using the definition of paragraph 56 to interpret it. Then the judge goes on to deal with expectation of success and what he characterises as being something done without any incentive of some immediate practical application. And we say he was wrong about that because he erroneously defined the skilled team and the characteristics of that team, and I'll come on to that in a moment. Next, he refers to the Charette and Gray point. That's part of the expectation of success, and I will deal with it under that heading when I come to it. And finally, he says there's an additional hindsight point in relation to Dr. Enright. So we see bound up in this paragraph the 3 headings which I'm going to deal with. The skill team, the expectation of success, and the hindsight point, and we say that he was wrong on each of those. So first of all, dealing with the skill team and the judge's mistakes in that respect. We can see in the judgment, the judge himself recognises the importance of the skilled team to obviousness in a number of places. He expressly recognises it in 266, and we'll come to that in a moment. But for now, can I just ask you to look at paragraph 416, which is the second of the two paragraphs I already referred to. And in the first sentence of 416, the judge is there accepting that what Dr. Enright proposed was routine and meritorious for Dr. Enright's skilled person. But he goes on to say
it was routine. He says it was
well,
scientifically meritorious, but I don't think the word routine is there, is it?
he doesn't use that, but I'll come on to explain why that's what he had in mind when he was writing this. He goes on to say it's not obvious because Dr. Enright defined the wrong skilled person, and he goes on to say that the finding of obviousness can't apply to results which can't be predicted or where there is not a good chance of a practical result. That's his last sentence. But in expressing himself that way, we say he is rewriting the statute and replacing the word obvious with the word predictable, and he's also adding the gloss of having to have a practical result. And in our submission, something can be uninventive and routine to do, even if the outcome is unpredictable. So it's not right to say something is not obvious just because it's unpredictable. And of course, as I explained earlier, one has to remember that the claim in this case is just to making the molecule of mRNA containing N1-methyl pseudouridine. All that needs to be obvious, therefore, is making that molecule, which UPenn expressly invites you to do for reasons which we've already been over to a greater extent. And again, I remind your lordships, Moderna abandoned any attempt to say that N1-methyl pseudouridine was better than any other pseudouridine, as the judge recorded, or any other, was better than pseudouridine, as the judge recorded in paragraphs 421 and 422. And so that confirms that the target for obviousness is simply making this alternative molecule in order to carry out tests. So, my lords, I'm going to deal with the three errors: skilled team, expectation of success, and hindsight in that order. Firstly, skilled team. So if we could go back, please, to the judge's findings on this, which start at paragraph 256 of the judgment. And there the judge correctly identified the differences between the parties. Moderna's focus was on what Professor Rosnecker termed transcript therapy. That is to say, gene or protein replacement therapy.
Yeah, just before you go on, can we just get a linguistic point out of the way? I'm sure it makes no difference for substance. You've referred to the skilled team. The judge here is referring to the skilled person. As usual, it might be one or two. It doesn't matter in principle, but nevertheless, so as we're clear, is this really a team, or is this really a person?
Well, it's in fact, as the judge goes on to find out, multiple teams. So there were multiple different groups who would be interested in
That's looking at the real world.
That's looking at the real world. And so, and the judge goes on to we refer to inhale.
Well, let me rephrase my question.
Yeah.
I apologise if I wasn't sufficiently clear. The judge states it in terms from which one understands that it was common ground between the parties that it was a skilled person and not a skilled team. Was he in error?
He was not in error in that respect. It was a skilled biologist.
Right.
And what was in dispute was what interests the skilled biologist would have in the various fields that we're going to come on to look at.
Yeah, I mean, in the real world, the skilled person would be embedded in a team. We know that.
Yes.
But we can focus on the individual.
We can, my lord. I'm sorry. And my own friend says it's in 117 is where the judge explains this.
Yeah, thank you.
Great, I apologise for not answering the question the first time. So the position as the judge sets out in 256, Professor Rosenecker was personally interested in replacing faulty genes in cystic fibrosis patients. That was his particular interest, and that's why he referred to what we call transcript therapy. But on this side of the court, we submitted that the interest of the skilled person was much wider than that and covered any work where it would be useful to have an mRNA which was less immunogenic and was translated more efficiently. That's covered by 2562 as the judge set out. And then the judge correctly sets out the problem to be solved at 257 and 258, which I've been over with your lordships already. And that is to say the decreased immunogenicity and increased translation efficiency. And then 259, the judge says he's not bound to follow either party's formulation, but he says that the upshot is more in favour of Moderna on the skilled team, the last sentence. But we say that just doesn't make any sense in the light of what he then goes on to set out. Because in 260, he runs through the 9 areas of work which we had identified as areas in which a solution to the problem which the patent aimed to solve would be of benefit. And if you look at that list on the following page, Moderna's case was that it was the 9th category alone, gene or protein replacement therapy, otherwise referred to as transcript therapy. But the judge rightly found that this was not the case, and he accepted our contention that the field covered all 9 of the areas which he lists in paragraph 260. So how the judge could describe the upshot as being more in favour of Moderna is baffling, given that he rejected their attempt to limit the team to 1 out of the 9 and instead accepted that all 9 types of person would be interested in mRNA which had better translation and lower immunogenicity. So we say there seems to be a clear error in 259 when he says that his findings in favour of Moderna. Now, the judge in 260 says he doesn't need to go into the details of all the fields which he sets out. And we don't criticise him for that in the judgment, as long enough as it is. But I can show you how we put it before him and how you can see that the judge accepted the submissions that we made to him in closing in relation to each of these 9 fields. So if your lordships would please open up the supplementary bundle at tab 20. And if you have paragraph 260 open alongside, and what your lordships will see is this is an extract from our closing submissions at trial, and paragraph 44, we have just above 44 the heading, the established field in which the problem lay. Paragraph 45, we, in the last sentence, refer to the agreement as a matter of common general knowledge that IVT, in vitro transcription products, are useful therapeutic and research tools. That was part of the common general knowledge statement, and it's recorded at paragraph 188 of the judgment. Then, in 46, we deal with Dr. Enright's explanation as to what he understood was the descriptors downstream therapeutic applications and more fundamental upstream research, and he wasn't challenged on that. So if your lordships would just read 46. And then in 47, we referred to the fact that this reflected the work of both experts. And if your lordships would just read 47A, where Dr. Enright, we quote from Dr. Enright's cross-examination. And just for your lordship's note, the judge accepts this this evidence in paragraph 51 of the judgment, where he refers to the aim of Dr. Enright's work generally as being directed towards therapeutic use in the end, as he says. And then we go on to set out A, B on page 297, C on page 299, various headings of work which were all put to Professor Rosenecker, and which Professor Rosenecker agreed people in that field would be interested in an mRNA which had better translation and lower immunogenicity. I'm not going to go through all of them in detail, there's no need to do that, but your lordships can just see, if you look at the heading, little a, so bit A in the middle of 295 corresponds to the judge's 1 in paragraph 260, and then B, 2, C, 3, etc. And I just want to pause on...
Sorry, just before you do, can I just make sure I've understood the point you're actually making at the moment? I mean, the target of your criticism is what, the last sentence of 259? Of the judge's 259, is it?
Yes, and it's then what he goes on, having made the findings that each of these fields is relevant, he nevertheless still goes on to reject the evidence as given from the point of view of someone in these fields. So he rejects.
But I'm just sorry. Have I misunderstood this? He in 259 he sets out the two rival contentions.
Yes.
And he says, in fact, I'm not bound to choose between them.
Yes.
In fact, I reject both. But the upshot is more in favour of Moderna, and that's the bit you don't like.
Well, that's one point where we say it's clearly inconsistent with 260.
Well, and
we say he was...
And 261
and
262?
Yes, because we say that he has...
Is it a typo? I mean, what does he actually... Because it... I mean...
Well, it's very difficult to understand what the judge really meant here, because as I'm going to show you, in relation particularly to...
I mean, did anybody, when he sent out his judgment in draft, query this?
I'm not aware that we, on this side of the court, we did.
How can you reckon? I mean, is the last sentence of 259, the very last bit of the last sentence of 259, reconcilable with what he says in 261 and 262, just as a matter of pure linguistics?
Well, if you ignore 260, it might be possible to reconcile, but it makes...
Well, no, because in 261, as my lord has pointed out, he says Moderna is wrong. And in 262, a further reason to reject Moderna's narrow definition.
Yes, so he's certainly rejecting Moderna's definition, but that's why it seems very strange that he says the upshot is more in favour of Moderna in 259.
Yeah, well, that's what I've just said. I mean,
yes.
If this bit of your submissions is purely and simply directed at the last phrase of 259, and we're going into all sorts of...
It goes further.
I'm sorry, Lord, it goes much further than that, because we say he's taken forward the wrong definition of the skilled person when he comes to look at the issues of obviousness.
He takes it beyond 261 and 262 into the rest.
He does.
So, okay.
So I hope I can make my submissions clear once I've shown you just what I wanted to say expressly about 260. We're looking at studying gene expression. This is little 4 in 260, and that is the subject of our submissions at bottom 299 of the supplementary bundle. And we introduced, in 63, we introduced reporter proteins, and I've already talked about those. And then 64, we have a quote from Dr. Enright. There's a myriad of different uses I can think of for an mRNA that can be transfected, translate efficiently, etc. And then we give the examples from this field, which include the work of Dr. Enright in little a, where he was using IVT mRNA encoding reporter proteins to assess the efficacy of miRNA in zebrafish. And we have the Desmet work, and we have the Carico 2008 paper, which also comes under this field. So we expressly point to the fact that the judge finds that the work in this field is part of what the skilled team would be, or people in doing this sort of work would be interested in mRNAs which have better immunogenicity and translation. And that expressly included the work of Dr. Enright when he was using reporter proteins in zebrafish. And so we say that by accepting little 4, he must have been accepting that Dr. Enright was doing the sort of work that the skilled team would have been doing at the priority date. Yet he goes on to reject Dr. Enright's experience and evidence by saying he's outside the skilled team. We say that's a mistake. And furthermore, we say it isn't just a single error he makes, because if you go on to look at E, which is studying mechanisms of translation and immune response, you'll see there were papers put to Professor Rosnecker on that front, listed on page 301 of the bundle, and Professor Rosnecker accepted in little a, second sentence, this work was fundamental research. Professor Rosnecker accepted in B2 that it described fundamental research. And so, again, the judge is accepting that this fundamental research area is part of the relevant field for the skilled team. And the same can be said for the zinc finger nuclease technology, the neuroscience research, developmental research in the judges 6, 7 and 8. And you can see over the next few pages description of that sort of work, the acceptance by Professor Rosnecker on multiple occasions that this sort of work was part of fundamental research as well as going beyond. And you can just see from the basic description, developmental research, neuroscience research, this is work that is not immediately going to be put into humans. This is further back, further upstream, as Dr. Enright described it. And so we say it's clear by accepting each of these different 9 fields in paragraph 260 that the judge was including a vast selection of different teams, all of whom would be interested in an mRNA which had better translation and immunogenicity, and that this field expressly included someone like Dr. Enright, who was working using reporter proteins, as we have seen. There's one final reference just in tab 15 of this bundle at page 255C of the bundle, which I'm afraid I have no idea what electronic page that is for my Lord versus Snowden. It's the...
I can tell you it isn't actually in the electronic bundle.
I do apologise.
It's 255C.
Yes, it's page 116 of the transcript, of the mini transcript.
Just give me a second. This is the core?
No, it's supplemental.
Supplemental,
yes.
Okay, sorry, there may be one. In which case, sorry, 255. Sorry, just give me a second. 259.
I'm told it's 259 in the electronic. I'm grateful.
Bingo. Yep, it is there.
I'm sorry. And so on page 116, this is my learned friend cross-examining Dr. Enright, and he asks the question at line 7. He says, now there are a number of reasons for using reporters like GFP and luciferase? Yes. And he goes on, asking further questions. Then at line 19 he says, now, you refer to messenger RNA encoding reporter genes as being delivered for visualization and quantifying gene expression. Indeed, yes. Presumably the kind of experiments we saw in your earlier publications that we looked at today. Absolutely. In evaluating the effect of microRNAs on mRNAs, siRNAs or microRNAs, but there are many, many others ways where transfectable messenger RNA that does not cause immunogenicity and is translated effectively would have been extremely useful. And he goes on to give examples of mouse work, etc. So it's clear there, first of all, my learned friend is connecting the use of reporter proteins as used by Dr. Enright in the paper that we've referred to under little 4 of the judge as being part of the relevant field. And then Dr. Enright going on to explain, yes, it's a practical use in that field, also a practical use in many other fields as well. So we say it's clear that Dr. Enright did envisage the skilled person as having a practical interest in the use of mRNAs of this type. Now, I think I've already referred to you that the judge himself found that IVT products were useful in both therapeutic purposes and for research tools. That's paragraph 188 of the judgment. And I showed you the reference in the patent, paragraph 21 of my learned friend of Moderna's patent, to the reference to diagnostics, reagents, and biological assays. So it's clear from those 2 references as well that the use of mRNAs in these additional fields was also part of what the skilled teams were doing at the time. So we get to the judge's finding in 261, where he says all of the above teams are looking for practical results. And we agree with that, but it also must follow, as a result of his observation there, that his conclusion about little 4, and indeed the other ones I referred to, means that Dr. Enright's team was also looking for practical results, because the judge has included in his list a field which covered Dr. Enright, as I've shown you. And that's consistent with the explanation that Dr. Enright gave, that all research is directed towards a practical outcome. So when he comes on in 262 to reject Moderna's contention on the skilled team because of the claims in the patent, and when he defines in 263 the skilled team as including any of the fields above, he must be including Dr. Enright and his practical interest in improving the use of mRNA, as well as the other fields which are more upstream or more in the nature of fundamental research that Professor Rosenecker had agreed, i.e. 5, 6, 7 and 8. And that is precisely what the sort of team that Dr. Enright proposed for taking forward the UPenn document, somebody with a practical interest in improving the translation and immunogenicity of mRNA, and that's precisely what we submitted in closing the skilled team, how the skilled team should be defined. And so when the judge in 265 says that he has arrived at something unusual, that is to say, a broad field with subfields, that of course is fine and correct, because that's what we accept, what we submitted to him. But then he goes on to say that Dr. Enright was not from one of these subfields because he was a pure basic scientist, in the words of the judge. It's the last line of 265. But that is completely inconsistent with his finding above that studying gene expression was part of the relevant field, which is exactly what Dr. Enright was doing, and he was cross-examined at some length by my learned friend in relation to one of the papers from that field. So we say the judge, having made the findings that he did about the 9 fields, was then wrong to exclude someone with the views of someone like Dr. Enright from that team. And in doing so, this is a relevant part of his these conclusions of the judge go to the heart of his findings on obviousness, and you can see that in paragraph T266 in the first sentence, where the judge acknowledges that there's an important interface between the argument over the skilled addressee and the right of approach to obviousness. And he suggests in 266 that on this side of the court we were pitching for a skilled person who had no practical goal in mind. That's about 7 lines down. But that's absolutely not the case. That's absolutely not what Dr. Enright's position was, what our closing submissions were, encompassing the fields that the judge found were correctly identified. And we emphasise that Dr. Enright accepted and indeed explained that it would be practically useful to have an mRNA molecule with lower immunogenicity and efficient translation. So he did have a practical interest in the outcome, and the judge was therefore wrong to exclude a person with his characteristics from the skilled team. It goes without saying that, following Lord Justice Jacobs' guidance in Technip, you shouldn't exclude evidence from an expert even if they do not themselves embody the skilled person.
Yes, but not everybody's familiar with that authority, so
No.
I think you need to take the court to that.
I will do so. Can I make the submission, and then perhaps I can show the court after lunch. Here the mistake the judge made was to exclude Dr. Enright's evidence, even though he did in fact embody the skilled person that the judge had identified. So it's almost a reversal of Technip, and we say that was a significant fault that runs through the findings of obviousness that the judge goes on to make. So if that's a convenient moment, my lord, I can pick that up at 2 o'clock.
Thank you. We'll actually start at 2:05.